All right, so we will call to order the July 25th special meeting. Um, Clerk, will you call the roll, please? Sorry.
Chair Ray. Commissioner Strebs.
Here.
Vice Chair Taylor.
Here.
Commissioner Wheeler. Commissioner DeLu.
Here.
Commissioner Gisler. Vice Chair Pro Tem Hepler. Commissioner Mazer. Commissioner Morales.
Present.
You have 5 present.
Thank you so much. All right, moving right along, we will start with our first interview. We have Stephanie Lang. She is present. You can come up and have a seat.
So see it'll go red.
Hi, welcome. Thank you for meeting with us today. So how the process is gonna work, we have 10 questions, so we'll each go around, introduce ourselves. Since there's only 5 of us, we'll go around twice and we'll ask you a question, you answer it, then we'll take time to answer any questions that you may have for us, and then that'll be it. But thank you for joining us. I am Tammy Ray. I serve as the Commissioner for District 1, and I'll start with the first question, which is please provide us with a concise 2-minute overview about yourself, specifically highlighting your education and experience as they relate to the position of Corporation Counsel.
First of all, thank you so much for having me here today. It is really an honor to be here today. Basically, I have worked in the public sector for over 15 years. I am excited to have this opportunity to meet with you to discuss my qualifications. I basically have worked as an attorney as well as a HR, human resources professional. Currently, I serve as a Chief Human Resources Officer at Tarrant County 911 District. In that position, I have had the opportunity to basically provide guidance, not only to the Board of Managers there, but also the Executive Director, as well as the Deputy Director and department heads. In that position, I provide guidance regarding the operational side of things. I provide strategic planning overview for the operations. My overall goal, obviously, is to shield the district from risk, making sure that decisions are made, they're in compliance with the law. They're basically decisions that are basically important for the citizens to make sure that we provide them a quality of life. And so overall, in that position, I am drafting policies. I am basically responding to Public Information Act requests. I am reviewing contracts. Every now and then, I am obviously providing advice in terms of what our position should be on contracts. I'm looking at making sure that the executive directors as well as employees are trained on making sure that we stay in compliance with the law and the regulations. And so that's my overall goal there at the district. I have also served in several other positions within the local government sector. I have served as a deputy city attorney. I have also served as an EO compliance officer. I have served as a legal counsel for the chief of police. In those positions, obviously, my goal is to make sure that I protect the entity, making sure that the executive directors, as well as the commissioners, city managers, making sure that they all have the information they need in order to make an informed decision. In those positions, I have been very, very grateful for the opportunity to build relationships, because I do realize when I'm working with a team, in order for me to be able to advise appropriately, I have to build those strong relationships. In building those relationships, I'm able to collaborate. One of the biggest accomplishments I feel overall that I have been able to do is contribute very positive to the organization from a cultural standpoint. A lot of times there are ethical situations that come up. It's so important for me that I be a part of an organization that feels strongly about employees having a passion for what they do and helping the citizens. And so I have been in that situation where I have been given that opportunity to make sure that I advise appropriately. And so a lot of times what I find myself doing is making sure that the leadership team, they're not blindsided. I'm making sure that they have all the information they need so they can respond appropriately to citizens and also employees and make sure that they make the best decision. You asked about my education. I have a bachelor's degree from Alcorn State University. I also went to the University of Memphis in Tennessee. There, I obtained a certificate as a legal assistant / paralegal. I also ended up going to Thomas M. Cooley Law School in Lansing, Michigan, which I'm so proud of. It was a wonderful experience. I had never lived in Michigan before. Stayed in Michigan for 10 years. I'm so grateful. In that particular role, I was basically still able to work in the legal field while attending Thomas M. Cooley Law School. I worked for Attorney Morton. I also worked for the School Board Association. In the School Board Association, I had the ability basically to help superintendents and principals. Anytime they had legal questions, I did the research, analyzed any issue that they had, and provided them with a response. The first position I had after graduating from law school is UAW Legal Services. With UAW, that was an excellent position as well because it helped me to work on my multitasking skills in terms of handling maybe over 150 cases at one time. So I became very good in basically working in a lot of areas of the law that I was unfamiliar with. But that experience was great because throughout my experience in the public sector, a lot of times, especially when you're working to give legal advice, there are so many issues that come up in so many different areas of the law. You may have property law, you may have contract law, and you have to be willing to get uncomfortable and be a little bit unfamiliar and make sure that you research, don't give up, stay motivated, positive attitude. And basically, you have to be resourceful in making sure that you get the answer and you provide that legal advice.
Thank you so much.
Thank you.
Vice Chair, you want to take question 2 and then Commissioner DeLuke?
Sure. Thank you. I'm Vice Chair Commissioner from District 5, John Taylor. Imagine the county is facing a lawsuit regarding a land use dispute. How would you approach defending the county and what steps would you take to mitigate any potential negative impact on the county's operational and public perception?
Anytime that the entity is facing a potential lawsuit, the first thing I think is very important is to gather information. You want to gather sufficient information to make sure that you have a good understanding as to what the facts of the case are. You want to make sure that you look into the allegations. So the first thing that I normally do is take a look at the complaint itself, look at all the allegations in terms of following up with research. I may have to follow up with department heads, as well as any particular parties within the entity to ask questions because I may need more information. I'm going to review all the information. And then at that point, what I'm going to do is see if there is any immediate action we need to take in order to mitigate. Because sometimes there may be some things that we need to do to ensure that we put ourselves in a good position. You know, as any attorney, we always like to be able to be involved as early on to sort of create the fact and establish the facts along the way, rather than just having the facts presented to us. And so that's one of the things that I think is really important, is to make sure that I sit down with the various department heads and any parties that's involved. And we need to sit down and have a discussion and make sure we collaborate about the situation and see if we can mitigate as much as possible. The next step also that I'm going to do after I try to mitigate, I'm going to make sure that I follow up with the board to make sure that they understand the facts of the case. I'm going to give the board an opportunity to understand what the facts are and make sure that they understand, here are the potential options that we have. If we follow option A, here are the potential risks that we could potentially have if we go this direction. And I'm gonna make sure that I provide a sound analysis based on case law, based on the law, regulations, based on the facts that we have them, to provide you with some feasible options for you to make an informed decision. But I want to make sure that you do have a good idea of what the risk would be.
Hello, Ms. Lang, I'm Dale Duluth.
Hi.
If a county department head approaches you with an urgent legal issue involving potential contract violations with a major vendor, what immediate steps would you take to address the situation and protect the county's interests?
If I had a department head come to me because they had concerns about a vendor potentially violating the contract, the first thing I think is very important is that I need to take a look at that contract. I want to make sure that I understand what the terms of that contract is, and then I'm going to follow up not only with the department head that came to me, but also maybe other individuals to find out what has occurred from a factual standpoint. What terms have been met? What are the alleged violations that the vendor did not satisfy? And then I'm also going to try to find out what action, have we took any action to put the vendor on notice so the vendor can know that the vendor may be potentially in violation of the contract. Because the first thing that I would do is, if I do find that there is a violation, I think it's very important that I draft a letter to specifically put that vendor on notice and give a certain time limit for the vendor to actually remedy. And then at that point, I would continue to work with the department head to see how the vendor is doing, following up, see if there's anything that we need to put in place. Now, sometimes when we have vendors that are in violation of the contract, it may have an impact on the entity, on the county, that may not be very feasible for us. By that, I want to understand, by the vendor violating the contract, have we suffered any damages? How has those violations basically impacted the county? And if it has impacted the county in a negative way, it may be where the department head is wanting to go ahead and try to see, can we get out of the contract as well? So when we look at the situation, depending on the extent of the violations that has been committed after we put the vendor on notice, and let's say the vendor has not remedied the situation, and we look at the impact of the damage, and we feel like it's more feasible and in the best interest for the county to get out of the contract, then we will look at those options as well. We will look at the damages, what if we try to get out of the contract, what would be the risk, what would be the damages? So I'm going to look at all the different options that's in the best interest of the county to make sure that we act in our best interests. And so that's something that I think would be a discussion, obviously, for the board, if need be, to make a decision on how the board would want to go forward. Thank you.
Thank you, Chair, and welcome to you, Ms. Lang. Thank you for being here
Thank you.
with us. So I represent District Number 2. It's parts of the city and township of Kalamazoo and Western's campus. And I'm going to give you question number 4. Here, I want you to suppose that you discover that a recently implemented county policy may unintentionally discriminate against a specific group of employees. How would you address this issue and advise the board on the necessary legal and procedural steps to rectify that situation?
Well, one of the things I think is really important for the board is that we ensure that we are in compliance with the law. And if we had a policy that just didn't meet that standard, I would bring that to the board. But before bringing it to the board, I think it's really important that I have all my facts. I have all the facts, and I need to have data or the information really showing that that particular policy has that systematic impact of discrimination. Once if all the information shows that it did, then I would recommend that that policy be modified. First, I would talk to the department heads or the departments that's impacted, and I would collaborate with them in terms of the policy, the language, learn what the intended, what was the intended effect of the policy? What do we want to see the policy do? Because even though the policy may have a discriminatory impact, we don't want to actually lose what was intended for the policy to rectify. And so I would make sure that I work with the department heads or any other employees that I need to make sure that that policy is written more appropriately and make sure that it is aligned with our policy of non-discrimination. And so in modifying that policy, of course, sometimes we do have committees, policy review committees. I will work with those individuals as well. Get as much collaboration as possible to make sure that we don't change the actual substantive meaning of the policy, and just immediately just come to the board with a modified policy for that policy to be changed.
Thank you.
Thank you.
Thank you, Chair. Welcome, Ms. Lang. Commissioner
Thank you.
Montice Morales, representing District Number 3.
Thank you.
Your question is a scenario-based question.
Okay.
You are tasked with negotiating a settlement for a high-profile lawsuit against the county. What factors will you consider in your negotiation strategy, and how would you ensure the best possible outcome for the county? Want me to repeat?
I think I was just thinking, okay, I think I'm ready now. I think one of the things when you're dealing with a case, especially when you're negotiating a case, you really want to make sure that you evaluate the case very thoroughly. And when I say evaluate the case very thoroughly, what are our chances of actually prevailing? If we file a lawsuit, will we be able to prevail in the litigation potentially? Do we have a good, strong case? Or do we have maybe some gaps in the case that we need to recognize? Or a lot of times, sometimes it may be just from the political standpoint or from, when you outside looking in from the public standpoint, maybe it's just not a case that we feel would have a good look, even though maybe it's not a case where we have done anything wrong. Sometimes from just the political standpoint, the case can have a huge negative impact, depending on situations that may be currently ongoing from a public standpoint. And so I will look at basically in terms of negotiating a case, how we negotiate a case what do we have available in terms of, from a financial standpoint? Is it reasonable at that point to settle the case? And basically what I would do is make sure that I share all that information with you in terms of our chances of winning the case, the gaps or weaknesses we may have in the case. Are there any alternative solutions in terms of, if we negotiate a settlement, what kind of impact would it have? Would it set a precedent? If it's something where from a financial standpoint, maybe it's not something that we want to do. It just really depends from a cost analysis standpoint and from the public standpoint, how it would be viewed and just what kind of impact would it have on the county overall from a morale or from an employee, maybe an employee morale standpoint. It could be a public, it could be just any of those things. So all of those, I would make sure that I share that information with you so you could make a sound judgment in terms of should we negotiate a settlement for this case. A lot of times when it comes to settlements too, and I always try to make sure that I share this information with the board. A lot of times the board don't really realize how expensive litigating a case can be. It's a lot of time, it's a lot of money in attorney fees. And then sometimes it also sort of depends on, do you have sufficient evidence? Is there, do you have the right witnesses? Do you really have strong witnesses? Sometimes you don't. Sometimes it may be that the opposing party, they can really represent themselves very good. Maybe they may have a lot of pull in the community, so sometimes that can be a huge factor on whether you want to move forward with a case. And so those are things that I would share with the board and ask that they consider. And if the board say, hey, Stephanie, let's negotiate this case, then my goal would be to look at everything that the board wants to consider in terms of the financial aspect, the timeline, and I would work hard to make sure I get that case settled if that's how the board will want to proceed.
Thank you.
Thank you.
Imagine you have to advise on a legal matter involving a potential conflict of interest for a county official. How would you approach the sensitive issue to ensure ethical compliance and maintain trust within the organization?
When you're dealing with a potential conflict for interest, sometimes I think for a board member, it may be a perceived conflict of interest. Normally when this has happened or when I've been dealt with a situation like this, I would normally, first of all, look at the policy. I will ask questions of the executive to see, is there a personal interest potential or a financial interest in any kind of way? And I will advise the executive member about that potential policy. The other thing that I think is really important, if there is any doubt or question whether there's a conflict of interest, or maybe it's just sort of from a timing standpoint and the matter is about to come up, maybe we can't give a clear answer. I would recommend as an abundance of caution that executive member go ahead and disclose that, fill out the affidavit, and just refrain from voting on that matter. Because we want to make sure that we do comply with that ethical obligations that we have. And it's so important that if we can clearly say that it's not a conflict, that the executive member go ahead and move forth and do that affidavit.
Thank you.
Thank you.
Under Michigan's Open Meeting Act, when may the board properly enter a closed session to discuss litigation?
Okay. Typically for Open Meetings Act, the board has the opportunity to go in executive session if they're dealing with a matter where there's a potential for litigation and they have confidential information that they do not want to disclose. And the reason for that is that we would not want the adverse party to become aware of information that is confidential, because that would be potentially adverse for the county. And so if we are in a situation where there's been a complaint filed, or maybe the board has received a letter where there's an intent to potentially pursue litigation, and the board would like to discuss how they want to handle that. Maybe they want to ask questions about the particular allegations, how they should address those allegations. That is all those discussions are typically under attorney and client privilege. And so anything that would fall under there, you would want to make sure that you ask for an executive or closed session to be able to discuss that. And that protects the interests, obviously, of the county to make sure that privilege continues. Thank you.
Thank you.
All right. Can you describe your experience with labor relations, particularly in dealing with personnel conflicts and collaborating with labor counsel? Please provide a specific examples of how you have handled such situations and the outcomes achieved.
I have significant experience with labor relations in a number of the positions that I have served in, because my background has been a lot of employment law. I have worked with unions. I have interpreted agreements for unions. I have also worked in terms of when it was time to go back to the table to see what we want to negotiate for as the agreement with the union. I have done that as well, and I've been a civil service director just as well. I have a lot of experience working with a lot of employee relations issues. Specifically, one of the things that I have learned when it comes to a lot of those labor relations issues, it's so important to build relationships and collaborate, especially with representatives of the union. One of the things that's so important is making sure that your department heads really feel comfortable talking to you and bringing employment-related matters to you. They have to feel like you're going to be approachable, and that they can rely on any guidance that you provide them when it comes to employee issues. And they have to feel like you're willing to partner with them. I have handled a ton of labor-related investigations, as well as responding to EEOC charges. I have provided just strategic planning and guidance on how to handle those. I have attended EEOC mediations and even private arbitrary meetings. I have even represented the city on civil service and actually pursuing the case for them. One example that I have, and I'll give this one because this one was one that was very hard, I guess you can say. One of the departments that I worked with, one of the entities that I worked for, they had a union, and the employee was in the police department. And oftentimes with the police departments, those kind of labor cases become very sticky and very difficult because you're dealing with not only the union, but sometimes you're dealing with things that can just get really, really public when it comes to police officers, depending on what the situation is. With this one case, it was where the police department, they had a lot of practices that was very systematic and from a discriminatory standpoint. And so I did have a case where an employee had been there for a very, very long time. And she had claimed that she was being discriminated against. And a lot of things that was happening was just some of the comments that were being made by various police officers. And she felt like when she mentioned this to the chief did not do anything about it. And so the first thing that I was tasked with from the city manager was to make sure that I investigate the matter very thoroughly. And so that was one of the things that was done. After doing the investigation, I did provide my findings to the board. We had several board members that had questions and they were really concerned and wanted to know how we could handle this in the most effective way, because this employee was very publicly well known. And so we had to also deal a lot with public perception in this case, because this employee had actually went to the media. Not only did she go to the media, but she had also hired an attorney. And so we ended up, because it was so political and because after my findings, it was just sort of one of those cases where it could go either way very fast. The board decided that they were going to settle the case. But we entered into longstanding negotiations back and forth. But we were very successful because in the end of that, we were able to also make some changes within the department to address some of the concerns that were provided. And so that was a good one because I had to work not only with the chief, I had to work with the union, and I had to work with the board to just sort of combat some of that public perception. And so we did take a lot of action, and I'm proud to say that a lot of the guidelines that I provided, it did make some great changes in that department, and the culture overall in that department actually changed. Thank you.
Thank you. I was still writing some notes. So, all right, our next one is, how would you ensure compliance with the Freedom of Information Act, FOIA, within the county?
One of the things I think with the Freedom of Information Act, I think it's important to remember why that act exists. Overall, for the most part, most things is information that is considered public. So one of the things that I think is really important is remembering the rationale behind the Freedom of Information Act. And it is so we can be transparent. It is so the public can get records for whatever reason. There are some exceptions, and sometimes we do have to follow up with the Attorney General's office, depending on what the situation is. Sometimes the rule is not as clear. But overall, when I get a Public Information Act, I typically will review the request. Sometimes I may have to ask for clarity, and so I will send the requester a response asking for clarity in terms of the request. Sometimes the request may need to be limited in terms of the amount of information the person is wanting based on how far the request may go back. It may go back to, I don't know, 2000. And that may be very difficult for an entity to gather that kind of information, or maybe it's just vague, it's a vague request. And so normally I'll try to look at the request and see if there is any clarity that's needed. If there's no clarity needed and the request is very concise and I don't have any concerns in terms of disclosure of the information, then I will reach out to the various departments to obtain the information and provide a response within the 10 business days for the requester. If more information is needed, or if I have to go to the Attorney General's office, then I'll still provide a response, but I will go further to see if we need to exclude this, if it meets one of the exclusions under the FOIA Act. But I do believe in being very timely, and I would make sure that I would ask the right questions to represent the county the most appropriate way.
Thank you.
Thank you.
Last question. Do you have any questions for the board?
Yes, I do. One of the questions that I have for the board is, this position is a very important position. And I think, you know, I feel like a lot of things that you have to do to be successful is that you have to be hardworking, you have to be very collaborative, have great research and analytical skills, and just willing to have that positive attitude to do what it takes to make sure that you provide the excellent service. But my question to you is, for you, and maybe in looking at persons who have previously served in this role, or just the role in general, what are 3 things that you think the person really needs to have in order to be successful in this position?
It's 9 of us, so this is just
Okay.
me. 3 things. Patience, because when we're back in closed sessions, a lot of times, you know, we're looking at new information that we have never been privy to. So sometimes you have, like, when I was a freshman, I came in on the squad here. A lot of things I didn't understand, you know, during my NEO year. And so there were times where I leaned on counsel a lot to answer questions so I wouldn't take up time during the meeting. And, you know, based on recommendations, I will follow back and be like, why do you recommend that? You know, what if we want to move forward? And we always get, you know, it would be, is that the will of the board? And sometimes, you know, and it is at the will of the board, but we want to respect your expertise. So one, having that patience, being thorough, like if we have, there was a time where we thought a motion was set and it wasn't, and there was some confusion about what the next task was supposed to be. And so never leave our chair hanging. You know, if you and the chair and the administrator have something going on, be sure to keep our chair, if any changes from any member of this body has said something, so that 1, the chair is not looking crazy. 2, we're not trying to write up something at the last minute and then there's conflict. 3, you got 9 attitudes to deal with. Just because Chair Ray wants something or Commissioner Stress wants something, Monteith might not want that, you know? And so not only when you say that that is an important position that you are the position, just like the administrator is the position. So we depend on both of you to work together so that we can have this understanding to make sound descriptions as you explain, you know, in your interview. So patience, being thorough, knowing your stuff. I might ask a million questions. Help me so we ain't back in closed session for 5 hours.
Okay.
So
Thank
I
you.
hope that helps you.
Yes, it does. Thank you so much.
That was good. Vice Chair.
Yeah, thank you for that question. I relish the opportunity to answer it. But I find myself in very much agreement with Commissioner Morales. The 3 things that number 1, this position is extremely important to the county.
Yes.
Behind Kevin's, I mean, it is the second most important position to this county as an entity. So hardworking is number 1. It's got to be somebody that comes in, and you mentioned the positive attitude. I think that's gonna that breeds longevity in my mind. Otherwise you get burnt out pretty quick. Number 2 is, as Monteith alluded to, it's the will of the board. Understanding that the roles, that the policy is created by the folks in the dais, and the hammer are you two, and you're the ones that get things done from an administrative or from a corporate counsel standpoint. So that understanding, I think, is important. And number three, you've got 9 different personalities, building relationships with the 9 different people and understanding
Yes.
that we're going to have a lot of different opinions. Commissioner Morales hit the nail on the head. We're going to have a lot of different opinions, but finding that consensus,
Mhm.
that majority of will of the board, so to speak. Sometimes it's a little more difficult than than you think, but I think finding that consensus of the board is very important.
I will add in brief, Chair, so. I am in agreement with my colleagues. I would just add, for me, another benefit is really being able to use your expertise to distill complicated
Mhm.
topics down into understandable
Yeah.
language, to help us have that language to discuss with constituents and with the community. And really how you talked also about that sort of like strategic
Mhm.
sort of perception, and really being able to see long-term, how do these impacts, what are the different impacts that you might look at here, and help us really visualize that to help us see the
Mhm.
course in front of us.
Okay,
Thank
thank you.
That last one was a big one. Thank you. Do you have any other questions for us?
I do have one more question. Let me see. My last question. One of the things that is so important to me, and I think I stressed it so many times, is just making sure that I'm in a place that really, really care about their employees. They really is really engaged with the community and just really want to make a huge difference. And so my question for you, in terms of just thinking along those lines, is what do you believe would be, when you look from that aspect, the corporate attorney in this position, do you feel like the corporate attorney position plays a role in just supporting you and building that cultural, and just being very meaningful in terms of helping the community? And if so, how do you see this position filling those shoes in that regard?
Chair. Sorry. I think that we as a board have moved tremendously in the last 2 years as it relates to your question. Kevin, his team have moved. We've got, we're hiring now a complicated, very, how do I put this? Very purposeful process in how we go about doing that. I look at it as the role is not just corporate counsel, but every single employee that works at the county is responsible for that cultural shift. I don't think you're going to have a problem with this board as a whole having that as a priority. We're going to look to this position as a way to keep us in the legal framework of what we need to do with the vision that we have as a board. But as far as this board caring about the diversity and the well-being of its employees, I think I would speak very much that it's a priority of this board, down to every single one of us, even some of them that are not even here. It's like they would say the same thing.
Thank you so much.
Thank
I
you.
really appreciate that.
Commissioner?
Thank you, Chair. So, as you can see, we're pretty diverse. Being the first Afro-Latina to sit on this board, it was a struggle coming in, just with learning how to get reacclimated in culture. So we have worked very hard in the last couple of years to, as Vice Chair, what's your name? Taylor, Taylor talked about with our DEI team. As you know, DEI is DEI. Culture is culture, depending on who's in leadership. And we can't make people shift their cultural values. Some people are stuck in their ways. So we do offer different modules for our employees to take part in. However, nothing is forced. You know, you have to be willing to make that change. I think we take culture, identity, and sense of belonging here very seriously, where we are not into pushing folks away. You know, even when we make awards, you know, you will see where our funding is diverse across the board throughout Kalamazoo County, where we're just not solely focusing on one group, whether they have it or not, or based on a culture. I have seen a huge cultural shift with a little more engagement than I saw in 2020, you know, into 24, as we're seeing with the changing times, you know, and government everywhere. You're seeing more people of color on dioceses and making more leadership moves. So I don't think that you would have a problem with your recommendations, and I look forward to, you know, whoever's privileged to get this decision, I mean, this position to keep us on track in that diverse sense legally, so that we are following guidelines, that we are taking new recommendations that we may not be, you know, privy to, so that we don't end up in closed session with cultural matters that could cost us money.
Thank you.
You're welcome.
Thank you, Chair. Again, in agreement with my colleagues. One other thing in your question I want to lift up too is about the culture that honors and respects and empowers our employees, but how that interfaces with the community that we serve. And I think a really important role for council here is really helping us take a look through policy about where are the places that we can identify maybe, you know, systemic things that have been at play for a long time, that become sort of ingrained within systems, that maybe create barriers unintentionally for people. And that ultimately then translates to how we provide more effective services to the people that need it from us. And I think that's a really, really important role, and one that I hope, you know, who we hire would champion for us. Thank you.
Thank you.
Thank you.
Thank you.
Administrator Catlin, you want to talk about next steps?
Absolutely, Chair. I thought you said administrator. Yeah. Oh, I thought you said administrator. No problem, Chair. No problem. Yes, so Board of Commissioners and Stephanie. So yeah, the next step for the board, so they have 3 other interviews to conduct yet today. The board will and can deliberate some today, but as you know, there are some commissioners that aren't here. So these interviews are actually being, because they're public interviews, are being live streamed and recorded. So we expect that the other commissioners will be able to watch those before or review those interviews before the next meeting, which is scheduled August 7th. On the board's agenda, they will deliberate those interviews and hopefully come to a decision on who they'd like to hire. And then that's when we'll reach back out to the successful candidate. So August 7th is probably about the earliest we'll get a decision, and we'll be in touch after that.
Thank you so much.
Thank you.
Thank you.
Hello, good evening. Is it Lou or Louis?
Lou is fine, ma'am. Thank you.
Looking pretty spiffy today.
Thank you. And thank you for having me this evening, Commissioners. I appreciate your consideration.
Thank you for coming. All right, so we have 10 questions. We'll each read two. As you can see, many of us are missing. And then we'll give you an opportunity at the end to ask us questions
Yes,
if you
ma'am.
have some.
Thank you.
I'll start. I'm Tammy Ray. I represent District 1. Can you please provide us with a concise 2-minute overall, or sorry, I'm so busy trying to say concise and put emphasis on it.
Yes.
That was so petty. I'm gonna start over.
Yes, ma'am.
Please provide us with a concise 2-minute overview about yourself, specifically highlighting your education and experience as they relate to the position of corporation counsel.
Thank you so much, ma'am. As my resume indicates, I am a graduate of Dillard University. I was a political science and economics double major with a minor in speech and drama. I attended, finally, when I got it right, law school at Thomas M. Cooley. It was my second time. I originally did a year at the University of Detroit, but I was young, I was making a lot of money, and I didn't have any children, so law school was just over there. But then I realized that if I wanted to continue to be in public service at a level that I felt I could make the greatest contribution, I had to get law school correct. And so I graduated from Thomas M. Cooley Law School in 2006 and passed the bar that same year. As it regards my career in public service, I actually started the day after I graduated from high school as an intern with the Detroit City Council. And in that experience, I saw the power what government has in order to make the lives of the residents of the city I worked in better, to provide services, to make sure that people had basic needs. And when I say basic needs, I mean simple things like streetlights, drains that didn't clog and get flood up the streets, because that becomes nuisance and dangerous. But just those things, and that government touches parts of every part of our life. From where a stop sign is placed to how much our insurance rates are. So I understand fully the importance of what it is that you have to do. After that experience and after graduating from college, I worked for the city's pension attorney, which gave me another view of how government has a duty to those who have been of service and to properly provide for them after service. And then from there, I worked with the Detroit Housing Commission. And I saw the interaction of the federal government with local agencies and with local governments and the power of what they can do and how they interact and work together. And shortly after that, I worked on Capitol Hill as a legislative assistant for Congressman Sander Levin. It's interesting that it has been on your agenda recently regarding the tuition reimbursement. That was one of the major pieces of legislation that I worked on in a bipartisan fashion, where we reached across the aisle and we got that made a permanent part of the IRS code, as that it had a sunset provision prior to it. And so I know, again, the power of what government can do to make people's individual lives better is a very, very real thing. After that, that's when I decided to go back to law school and to get it right this time, to do it right. And while in law school, I was a law clerk with the City of Detroit's law department, and I prosecuted in environmental court as a student. And again, it's getting people to understand the systems that have so much influence over their lives and how they work, so that they aren't intimidated by government, that we are here to serve and be of service. And then after that, I went back to the Detroit City Council Research and Analysis Division, helping work on policy, work on law and policy ordinances, if you will, also. And then from there, I was, if you will, recruited by the Corporation Counsel of the City of Detroit at that time to become Assistant Corporation Counsel and Legislative Liaison to the Mayor and City Council. And so I was part of the bankruptcy process, which candidly, I would tell you, burned me out. But it gave me a sense of people have to stand in that gap, in that stead for the residents which we serve, because that's really who all this is about. And then from there, I I was burnt out after the bankruptcy. I was. So I went and chased some dreams and went to Hollywood and went to acting school, which was actually great. And I have to honestly say, it made me a better attorney. As an actor, um, in school, it made me a better writer so that I'm writing to the audience specifically and addressing what their needs are and what it is that they desire to accomplish and to make sure that it's communication and understanding. I've gone over my 2 minutes, but the last thing I will say is that it also made me, in terms of making me a better attorney, it made me a better listener because as attorneys, you get the same thing. I was in a car accident and this, and you can almost write the script. But then there's that one little thing that if you're not listening, that will make that case or that matter different, you're gonna miss it. So it made me a better attorney in terms of my writing and my listening. Thank you.
Great, thank you. I have a quick question.
Yes, ma'am.
It's just lingering in my head. So we have a quorum, right? Exactly, enough people for a quorum. If I needed to go to the bathroom, will we have to stop or?
Ma'am, you only need a quorum present for actionable items, meaning to
Okay.
take a vote. The only motion that can be made without a quorum is a motion to adjourn.
Okay,
But other than that, receiving information, which is what this is, you're receiving information about me, is
Mhm.
perfectly fine.
Sounds good.
Yes, ma'am.
Vice Chair and then Commissioner DeLu.
I'm sorry. Yeah.
First off, thank you for being here.
Yes,
Greatly
sir.
appreciate it. Imagine the county is facing a lawsuit regarding a land use dispute. How would you approach defending the county and what steps would you take to mitigate any potential negative impact on the county's operational and public perception?
Thank you. One of the first things that I would look at in the complaint is, besides what is the county wrongdoing, alleged wrongdoing the county may be accused of, but is what was the public purpose being served in the land transaction, first and foremost. So to make sure that we meet that state statute criteria, that anything that this body does has to serve a public purpose. And so the analysis would come from there, would begin there first and foremost. I would also meet and talk with the people on our side who were involved in the transaction taking place in the first place. After that, I might consult with either outside counsel or inside or in-house counsel also, and then write an opinion expressing all the issues, both the pros and cons of our positions. And I put that out there because I realize I am not a decision maker. I am simply here to provide a legal analysis to this body. And I'd like to just one last point on that is that, yes, we can write policy for the body as corporation counsel, but we don't decide policy. My job in whatever policies you may adopt is to tell you whether or not it's legal. You can do that. Or no, you can't do that. And what I prefer when I have to say no is, no, you can't do it that way, but give me a chance to find a way for it to be done. And you can still be in integrity with your values as well as with what the law dictates.
Thank you very much.
Yes, sir.
I have to agree with you. I think all attorneys are actors. Okay, question number 3. If a county department head approaches you with an urgent legal issue involving potential contract violations with a major vendor, what immediate steps would you take to address the situation and protect the county's interest?
Thank you so much. I would find out where in the process we are in terms of dealing with that vendor to stop, first and foremost, whatever it is that is, if it can be. Because there may be a particular incident where it may be something with the health community services and they're providing us with a vaccine or something that we need, but we know that there's something wrong. But one of the first things I would do after conducting an initial investigation is put that vendor on notice properly so that there's no pushback to say, well, we didn't know. And then from there, consulting with in-house counsel, and if necessarily outside counsel, proceed from there with the best approach to get the problem handled in a way that this body would like.
All right, sorry, thank you. I'll reorient myself there a second, sorry.
Yes, ma'am.
So our next question is just suppose you discover a recently implemented county policy may unintentionally discriminate against a specific group of employees. How would you address this issue and advise the board on the necessary legal and procedural steps to rectify that situation?
Thank you. One thing that I would do first and foremost is make sure, in fact, that the policy does discriminate. Unfortunately, many times I've seen people have incorrectly interpreted what it was that legislative bodies intended. So once we make that determination, if perhaps a discrimination did occur, I would discuss with the department, with the heads, how we can redress that issue prior to bringing to the board. Because there are some things that happen that don't necessarily rise to the level of needing legislative I'm sorry, forgive me, or needing legislative attention, if you will, from this body. So once we figure that out and we resolve it and we see where that problem is and we substantiate the allegations, then make recommendations pursuant to the policies that are in place, and then ensure a follow-up that those things are taken care of. Because I have been in situations where department heads will set things over here that they don't want to deal with, and then they come back to bite the entire agency or company or department in the butt. And we don't want that to happen.
Thank you. Here's your big moment.
Yes, ma'am.
This is a scenario-based question.
Yes, ma'am.
You ready to put your acting skills on?
Yes. You have to pay to see that.
Well,
Over at the Civic, that's where I'm gonna go next.
you are tasked with negotiating a settlement for a high-profile lawsuit against the county. What factors would you consider in your negotiation strategy, and how would you ensure the best possible outcome for the county?
Thank you. I think one part is not just the position of the county, but also knowing who the players are, what attorneys sit on the other side of the table that we're negotiating with. What are their strengths and what are their weaknesses? And then after that, what are the strengths and weaknesses of our position, as well as the strengths and weaknesses of the other side's position? One thing also is I will work with this body to control, and with the communications officer to control the narrative of what is being told to the public, to ensure that it is, in fact, this is what's happening and this is the information that you needed, and making sure that we protect those things which are clearly attorney-client privilege move forward. So knowing the intricacies of that and developing a strategy and working not just with the departments, but also with the administrators to make sure that we bring to this body a solution that meets both the state statutes, the Constitution, and as well as what was the original goal and intention of that action.
Thank you. Next question. Imagine you have to advise on a legal matter involving a potential conflict of interest for a county official. How would you approach this sensitive issue to ensure ethical compliance and maintain trust within the organization?
Thank you so much. One thing that I would that I believe would have to happen is an individual meeting with the member of this body in a confidential setting to find out what their position is, how what their interpretation is of the events that led to that. And one thing that I would look into, especially if you thought you were acting under the advice given from Corporation Counsel, because I would want to check my office and myself to make sure that we're giving you the correct advice about what needs to happen, what's happening. And I know you are all familiar with the Open Meetings Act and the incidental quorums at an event that might be happening. So, and I've seen things like that get twisted where you might mention, oh, we're voting on purchasing a yacht for the county on Thursday. Did you see them? And somebody could overhear that and think that, hey, they're conducting business outside of a meeting, a formal meeting. So vanguarding against things like that would be paramount also. And can I just say, and I think Commissioner Ray could testify to this, is I'm not shy when the body may be going down a path it might not to. I will speak up, Madam Chair. So, but please never take that personal.
Thank you.
Thank you. Under Michigan's Open Meetings Act, when may a board properly enter a closed session to discuss litigation? I'm just tossing this up to you.
Okay. Well, as you know, under the Open Meetings Act, there are several exceptions for that. That could include personnel issues that might come before this body and the excuse me, and the employee has requested a closed session discussing real property matters, discussing pending litigation, and I forget the other two exceptions. Please forgive me for that. But I have to say, I'm very strict about that. And I'm sorry, I got an email. There was an email thread that said, well, you know, Lewis is about process. And it's true, because one of the things that I experienced as an attorney in the Detroit bankruptcy was that the major newspapers, they would look for every little thing in order to try to exploit that the closed sessions were not called properly. This evening meeting was not called properly. Things, it could be something as small as one little word that should have been there. So I try to vanguard against that happening because I know that they can be, if I just say, they can be ruthless. I'm sorry, that's just been my experience with the media, and they can be your friend also, but making sure that everyone abides by the law, because the law, one thing that I remember that was important for law school is that the law is for man, not man for the law, meaning that the law serves us, the law protects all of us, but we have to be willing to be able to stand up and say, sometimes, administrator, I disagree with you on this. But that's fine because I know he makes the final decision. But as long as I'm in integrity with what I believe and what I know I need to do, I'm okay with that.
Mr. Smith, can you describe your experience with labor relations, particularly in dealing with personnel conflicts and collaborating with labor counsel? Please provide specific examples of how you have handled such situations and the outcomes achieved.
Thank you so much. When I was with the city of Detroit, the collective bargaining agreements with the Detroit Police Officers Association allowed for police officers who had been denied representation by both Corporation Counsel and the Chief of Police to appeal directly to City Council. And that came up once. It had never been done in the 25 years that had been part of the CBA. So there was no mechanism and no process for it. Whereas two officers wanted to appeal to City Council. So working with the City of Detroit's Labor Council, working with the Union's Council, we came up with a hearing and what that would look like and where it would go. And it's my understanding that is still being used today in those cases.
Okay, thank you for that. The next one is, how would you ensure compliance with the Freedom of Information Act within the county?
Yes, ma'am. I would work with the Freedom of Information officer that the county has to make sure that we are meeting the statute, that we are not over redacting items, but by the same token, we aren't giving away more information than is required by the statute. I've worked with FOIA in the city of Detroit in terms of working with the Innocence Project, which you may have heard of, and they would request homicide and rape files. And so going through those, knowing how sensitive those documents are and what was required by the statute and what needed to be left in gave me great experience. I have redacted over 300 of those files. So I'm very familiar with the act and how it works.
Thank you.
Yes, ma'am.
Last question. Do you have any questions for the board?
What I would like to know is what priorities are you looking for that maybe have not, that are just ramping up, but you see it coming, that you believe Corporation Counsel might have a hand in bringing to fruition? And what should we be aware of looking for going forward in that regard?
Okay, there we go. One of the things that I've noticed over the last like 3 or 4 budget years is the amount of money that we spend on outside counsel. And when we have an internal counsel, how much money it saves the county operationally. What I envision this corporate counsel being this office, and I'm going to call it an office, is more than just a person, because the more we put in-house, not only the more control we have, the more institutional knowledge we keep on a case-by-case basis, but the more tax dollars we save as well, because outside labor council really runs up budget pretty high. And as we prepare our budget each and every year and we decide how much we're going to put towards outside counsel, it really behooves us as a county to have I say a stable, but a office of attorneys that can handle various different matters with different types of skill sets. So I guess what I see envisioning in this office the next 5 or 10 years is a level moving towards more of what the bigger counties have, the top 5 or 6 counties in the state have, as a professional sort of institutionalized corporate counsel office. And I think we're moving in that direction. So.
Thank you. And may I just on that point, sir, and Administrator Catlin can tell you one of my concerns when I first arrived as Assistant Corporation Counsel was the dollars being spent on outside counsel, because I know that those do add up fast. One thing that I would like to also see this body do, because I do know that there are law firms within the county that specialize in municipal law. I think we have a duty to circulate as many of the dollars that the county has within the county also. So that's one thing that I would like to also, if we can do that, still keep present outside counsel, but also move new business perhaps to counsel located within the county.
You're right more than you know.
Thank you.
Thank you, Chair. So along those lines, I think
Yes.
when I came in, we were still fluctuating with council, and I know that we have been paying, outside counsel for some time. And I think this board worked hard and through those trials to make sure, one, that we now do have an office, as Vice Chair mentioned, but two, being able to have competitive salaries so that people are not overworked and underpaid. And so my hope is that when we get through with these interviews, that we have a great supporting body. And I mean, the board goes off of recommendations. So, even if it's not you,
Yes.
that we still take heed to recommendations that you put forward to lead council. But I think we've done a great job with recognizing how much money we've been spending
Yes.
and investing in counsel that we can have in-house.
Thank you. Thank you.
Thank you, Chair. Thank you for this question. One other that I would lift up, I think it continues to be a primary focus of this board to advance initiatives around equity within how we manage county government and interact with our employees and culture, but also how that interfaces with the community. And you said something earlier within your interview, I think is really key to that. It's, there's a lot of pushback against efforts to advance equity in communities. And we'll see a changing legal structure that happens with, federal court decisions and state court decisions that can happen. But when you identify for us, understanding the intent of the board and then helping us see a legal barrier and finding a way to get to the outcome around it, right? So
Yes, ma'am.
being able to understand, we can't do it this way, but give me some time to research and let me find a way
Yes.
that we can get to the solution. I think being mindful of that and really getting the strategy and the vision long-term for the plan and for this community and the way we want it to grow in an equitable way is something that would be a priority for the office of the council.
Thank you. And may I just follow up on that? No, and I think that is so key. One thing that is core with me is that law cannot be practiced in a vacuum. It can't be practiced in an ivory tower either. You have to get out there and get to know the people, the situation, see what's going on in order to draft and strategize the best solution that you can, that I can, and offer to this body. And if I may, one example I like to give is, I'm not sure if this body has ever heard of petroleum coke, pet coke. It's a byproduct of refining oil into gasoline. Well, in Detroit, Marathon Oil Company was storing it on the riverfront, just storing it, and it was blowing into the community apartments, cars, and everything like that. So me and my law clerk at the time, we went to Marathon and we put on the goggles and the hard hats, and we went through and we saw the process and what has to happen from the time it's dropped into the truck to be transported. And that was key, meeting with the players at Marathon to come up with an ordinance that would allow for the proper storage of pet coke so that it was covered, so that it wasn't so expensive for Marathon, because we want to encourage business to be here because they employ the people who live here. But also, Chicago based its pet coke ordinance on the Detroit ordinance that I helped write. Actually, I wrote it. I'm sorry. This is the time not to be humble, right? I wrote the pet coke ordinance that I wrote so that another community found substance in what I put forward as a solution. Of course, working with others was very valuable, I think, and it demonstrated that when we put our minds to it, we can come up with solutions that work for all. And thank you, Commissioner Stretz, for that.
Do you have any additional questions?
No, ma'am, I don't. I just like to say thank you so much for this opportunity. And two things I just want to say. I really like Kalamazoo. I've lived here for just over a year. As some may have heard me say, it's like a small town dressed up in big city clothes. It has the arts, the theaters, the restaurants, but then there's still, I can talk to my neighbor. I can still see that smiling face. So I like it here. And even if I'm not offered the position, I am here. I am of service. It's the only way I know how to be. The last thing I'll say, shortly after law school, I was talking with my father about opening my own practice. I said, but it just doesn't do something for me. And he said, that's because you like to be of service, Lewis. And I accepted that. So service, especially public service, because my dad was a teacher and worked in the recreation department, and my mother was very active in the community. So it's something that's been bred in me, and knowing that that's what this position is about, being of service. Thank you.
Appreciate that. Administrator Catlin, you want to talk about the next steps? Thank you.
Oh, I'm sorry.
All right, thank you, Chair, Board of Commissioners, and Lewis. So the next step is the board has 2 additional interviews yet this evening, not afternoon, this evening. And then they'll actually reconvene on August 7th during Committee of the Whole, deliberate on the candidates and the, talk about the interviews. They'll likely be able to coalesce and come to a decision, align around a particular candidate, and then have that on the regular meeting to extend a conditional offer of employment to a successful candidate. And then we'll be in touch with that candidate and all others at that point in time. So about 2 more weeks and should have a decision. Yes, absolutely.
Thank you so much.
Chair, we do have the other candidate here. I don't know if you want to take a break or we can have them come on in and get started if you'd like. Okay, Dina, we'll be taking a 10-minute break and then we'll be back.
All right, good evening and welcome. Thank you for taking the time to meet with us today. We have 10 questions. We'll each go around and ask 2 questions, and then we'll give you an opportunity to ask us questions at the end. All right, so I'm Tammy Ray. I represent District 1, and my question is, could you please provide us with a concise 2-minute overview about yourself, specifically highlighting your education and experience as they relate to the position of Corporation Counsel?
Yes, thank you. Can everybody hear me okay? Okay, thanks. Um, Yeah, in terms of my education, I went to Western, graduated from Western, then went to law school in Detroit at Wayne State. After graduating from law school, moved to Kalamazoo and started practicing in the civil arena. I practiced in the area of estates, probate, elder law, disability rights for about 6 years. After doing that for 6 years, in 2014, I accepted a position as an assistant prosecutor for Kalamazoo County. I worked as an assistant prosecutor for Kalamazoo County for just under 8 years. I started off in family court, prosecuting child abuse, child neglect, and juvenile delinquency cases. I then moved to district court, prosecuting primarily domestic violence and drunk driving cases. Then after that, moved into circuit court where I prosecuted felony cases and was also the prosecutor's office's first treatment court administrator, where I worked with the 8 treatment courts in Kalamazoo County for the prosecutor's office. In my current position, I work for Canton Township. Canton Township's deputy township supervisor and general counsel. Canton's over on the east side of the state, western Wayne County. It's Michigan's 9th largest municipality. It's in Wayne County, Michigan. And in that role, I oversee 8 major departments, including police, fire, municipal services, leisure services, communications, human resources, and 2 others. I'm also the chief legal officer for the township. And so I oversee all litigation, prosecutions, employment and labor matters, um, you know, everything that's a legal matter, FOIA, the Open Meetings Act, everything that's a legal matter that is encountered within the township.
Thank you.
Thank you. John Taylor, good to see you again, Joe. District 5. Imagine the county is facing this lawsuit regarding a land use dispute. How would you approach defending the county, and what steps would you take to mitigate any potential negative impact on the county's operation and public perception?
Yeah, I think the first thing I would need to know is the type of land use dispute. When it comes to property disputes, there's several kinds of property disputes, but typically with a municipality, you're looking at easements, you're looking at rights of way, you're looking at public property versus private property. So I think the first step I'd want to know is what type of land use dispute is it, and if it involves easements, rights of way, some kind of pretty standard disputes that go on between municipalities and private parties. I would want to look back in chain of title, and kind of take it all the way back to see where these disputes originated. I think after doing that, and getting some information on where the land use originated, I would then, really need to kind of do some legal research on the particular type of land use dispute, meaning, researching statutes, researching case law. And then I think what I would do is I'd give the county my independent judgment on what the kind of correct legal position is on the land dispute. If the County Board of Commissioners decided to move forward with the dispute, either as a plaintiff or if it was a case that the county was defending, I would then, act as an advocate on behalf of the county's interests. um, and, also advise the county on how to mitigate risks throughout the course of that lawsuit. A big part of, I think, what municipal attorneys do and attorneys more generally is advise their clients on how to mitigate risk. And that is, really advising, their clients on what the pros and cons are of a particular lawsuit, and then, letting the client make the final decision on, whether to go forward as a plaintiff or to defend the suit as a defendant.
Hi, Joe Dale DeLu. If a county department head approaches you with an urgent legal issue involving potential contract violations with a major vendor, what immediate steps would you take to address the situation and protect the county's interest?
That never happens. That happens all the time. Yeah, I think the first step is to look at the contract, look at the language in the contract, and find out what the remedies are for breach. If there's a clause in the contract that provides, for liquidated damages, then I think the first step would be to begin assessing those damages. I'll say in the role I'm in now, the most often the violation that we see most often of an existing contract that we have is with our waste haulers. Our waste haulers often will pick up trash late. They will often spill hazardous materials onto streets and roads. And there are also issues that kind of go on with the landfill. And so in those particular cases, we have a provision in our contract that allows us to withhold payment when the waste hauler has violated the contract in specific ways. And so that does not require us to send a lawyer's letter to them and we're going to sue you and all this kind of stuff. We can just withhold payment when a violation of the contract has occurred in one of the specific instances that's outlined in the contract and that both parties have agreed to. So I'd want to look at the contract and see, if any provisions like that exist. If not, I think we would probably want to have provisions like that in our county contracts. And if we don't, and we need to pursue litigation for contract violations, then we can do that. Prior to doing that, because litigation is costly, contentious, and can go on for years, as all of you know. I might reach out to the vendor as well and find out, what the reason for the breach is and see if it can be resolved amicably.
Hi, Joe. It's good to see you as well. All right, so our next question for you, well, I'm Commissioner Strebs, I'm representing District Number 2. So suppose you discover that a recently implemented county policy may unintentionally discriminate against a specific group of employees. How would you address this issue and advise the board on the necessary legal and procedural steps that would be needed to rectify it?
It's a good question. We're going through this a little bit in Canton Township right now. Our Title VII and Title IX policies in the township are antiquated and they're outdated. And so we're in the process of updating those policies. But I think with a discrimination complaint, or even just, a policy that could be discriminating against people, I think the first step is to find out, if there's a complaint, what's the nature of the complaint? If it's a Title VII or Title IX complaint that requires an immediate investigation. So you conduct the investigation, and you kind of see what comes from that. There are instances when, particularly with Title VII and Title IX complaints, they can be forwarded to the EEOC, as all of you know. When that happens, the EEOC will do its evaluation, make a determination of whether or not, based on the complaint, there is a right to sue. Oftentimes, the EEOC concludes that there is a right to sue, although not in every instance. Um, and if that is, concluded, based on the complaint, then the county would need to prepare to defend itself, against that complaint. Oftentimes that can include looking at antiquated policies or policies that discriminate against employees and making sure those policies are updated. And I guess the second step, after kind of updating, a policy that might be outdated or um, discriminatory, is communicating that with the employees. If there's been no specific complaint from an employee, I think it's really important to get employee buy-in to any changes that are made within the organization. And we've gone through this over the past 3 years in Canton with our DEI initiative. One of the things I'm really proud about how we've kind of done that is we've brought all employee groups in, and we now have an internal committee that focuses on those issues with the employees throughout the entire organization. And we have representation in each department, within the township. And they give, all sorts of suggestions, to the leadership, within the township for change, with regard to, policies, culture. They collect data and kind of give that back to us in terms of, the kind of makeup of the township. They also put together learning events for employees that employees can participate in, to learn about diversity, equity, and inclusion in the workplace. So I think those are kind of the three things. If you have a specific complaint, I think that has to be addressed, in the right way. If it's a policy that discriminates, the policy needs to be looked at, needs to be revised. And you got to get buy-in, from the departments for that revised policy. And then I think the employees is the third piece, making sure the employees know about the changes that need to be made, are bought into those changes and know what they mean for them and their jobs.
Thank you.
Hello there. Welcome. Montes Morales, District Number 3. So this is a scenario-based question for you. You are tasked with negotiating a settlement for a high-profile lawsuit against the county. What factors would you consider in your negotiation strategy, and how would you ensure the best possible outcome for the county?
Well, my general approach to all litigation is a approach that will encourage settlement, because litigation is expensive, it is unpredictable, and can result in great consequence to both sides in any given case. That being said, sometimes there are cases that need to be litigated all the way to a verdict. As a prosecutor, I tried over 1,000 cases. I've done over 100 jury trials. And so I litigated cases every day, every week, every month for the nearly 8 years that I was in the prosecutor's office. So I know that there are some cases that need to kind of go to verdict. But if there is you said it's a high profile case, and there's sensitivity, to the case, I think probably the first step would be to um, have a closed session on the case to discuss settlement strategy with the Board of Commissioners and find out where each of the commissioners stands in the case and what each commissioner wants to see happen in the case. And get that feedback and get that input. And then, what I would do is provide the commission with, legal advice, independent judgment based on legal research, um, about the pros and cons of going forward with litigation, and what the risks and rewards might be of doing that. If it was the board's directive that the board wanted to move forward with the case, then I would move forward and zealously advocate on behalf of the county's interests. If it was the board's position that the board wanted the case settled, then I would do my best to settle the case short of the case going into a courtroom. So, in general, that would kind of be my approach. Um, you know, like I said, I think it's usually better to settle a case if you can get a reasonable settlement in a case than it is to go all the way to trial. But there are some cases where, you do have to stand on principle and you do have to take the fight to court.
Thank you.
Imagine you have to advise on a legal matter involving a potential conflict of interest for a county official. How would you approach this sensitive issue to ensure ethical compliance and maintain trust within the organization?
I think the first step would be to review ordinances and policies within the county to see if the conflict was, established by ordinance or established by policy. If it were, then I would point that out to that official. That there's a conflict that exists, and that if typically this is like with a vote of some kind. There's a conflict that exists. With this upcoming vote, my recommendation would be for you to recuse yourself, from this vote. But at the end of the day, it's the individual commissioner's decision, right? When it comes to these things. Um, so, so I think that would be kind of my general approach. If the conflict is not based in ordinance and it's not based in policy, if it's say it's a financial conflict or something like that, because those occasionally will come up. I would advise the commissioner of that conflict, and the commissioner ultimately would make the decision whether or not to stay in on that vote or to recuse themselves.
Thank you.
You're welcome.
Question 7, under Michigan's Open Meetings Act, when may the board properly enter a closed session to discuss litigation?
There are 13 reasons under the Open Meetings Act to enter into a closed session in the statute. When it comes to litigation, the board may enter closed session to discuss pending litigation and may also enter closed session to discuss settlement strategy. There are other provisions in the statute that are not necessarily related to lawsuits, but can have legal consequence. For example, certain sensitive personnel matters. There's a provision in the statute where the board may enter a closed session to discuss sensitive personnel matters. Often those kinds of personnel matters that require closed sessions do have some legal risk to them. Another issue and another reason to enter closed session that kind of touches the legal world is to discuss transacting real estate, purchase or sale of real estate. So those are some of the basis off the top of my head that come to mind that the board may enter closed session to discuss.
Thank you.
You're welcome.
All right, sir. Can you describe your experience with labor relations, particularly, trouble with that word for some reason, in dealing with personnel conflicts and collaborating with labor counsel? Please provide specific examples of how you have handled such situations in the outcomes achieved.
So in my role in Canton Township, I serve as general counsel, and I'm also the chief labor negotiator. And that was one of the first changes that I made when I got to the township. The chief labor negotiator for the township prior to my arrival was the human resources manager. And my sense was, at least in that organization and in that culture, um, having that kind of setup didn't do the employees many favors. Because oftentimes the human resources department was in the position of having to enforce contracts, and enforce contracts typically means, um, you know, tell an employee that it's usually something they don't want to hear. And so my thought was, human resources should really be there as a resource for employees, to help them with, workforce development and developing their careers. Um, so I've negotiated 5 labor contracts in the past 2.5 years. Canton has 5 bargaining units, AFSCME, POAM, they have Command Officers Union, TPOAM, which is the clerical staff for our police officers, um, and a 5th union. And so I'm the primary person who handles all contract issues, all grievances, and arbitrations. We've had 2 cases go to arbitration since I've been with the township. In terms of kind of what I'll paraphrase is like everyday employment matters. I handle those issues every day. So issues involving, um, discipline with employees, all the, from, step 1 all the way up to termination. Um, issues involving complaints made by employees or made about employees. And our human resources, manager kind of does the day to day with those kinds of issues, but they often make their way up to me, especially if there are sensitive legal issues involved. And so, in the role that I'm in now, that's I'd say it probably takes up 30 or 40% of my time. Issues with the employment culture, and issues that come up with our labor organizations.
I find my right page for our next question. So you share with us, how would you ensure compliance with the Freedom of Information Act within the county?
So in the role I'm in now, in a township, the deputy clerk acts as FOIA coordinator by statute. That's in the Charter Township Act. And so routine FOIAs are administered by the deputy clerk. That's the township clerk's deputy. We have 2 administrative FOIA folks in the township, one that handles general FOIA requests, and the other that handles public safety FOIA requests. And in terms of the volume, about 80% of our requests are public safety FOIA requests. The other 20% are just general government operations FOIA requests. I resolve FOIA appeals in my role. And so when there's been, and FOIA appeals typically come when there's been a denial of some kind or redactions of some kind when there's requested information. So the way that our policy is written, the township supervisor can resolve FOIA appeals, or the board can resolve FOIA appeals. I take vast majority, 90% or more of FOIA appeals to the board for resolution. I present the appeal to the board, and then I give a recommendation on how I think the board should resolve the appeal. But then the board takes a vote, whether to grant the appeal or to deny the appeal. I also handle FOIA litigation. We've had one lawsuit involving FOIA in the past 2 years. It was a case that predated me working there. And it was a dog bite case. Somebody called Sam. And after calling Sam, they FOIA'd a bunch of information on what had happened with that particular case. Turns out the information that they FOIA'd had actually already been given to them by the officer who responded to the dog bite. And so the case did end up getting dismissed. But yeah, I mean, I think, one of the first things I'd like to do with regard to FOIA is to review the current policy. If the board members think that the policy should be changed or should be updated, kind of get that input and get that feedback. And make sure that we're responding to FOIAs in the way that this board, wants to respond to FOIAs. I can tell you when it comes to FOIA, some of kind of my principles that I abide by are, transparency, being as transparent as we possibly can with the public's information, and being accountable when it comes to responding to FOIA requests. So making sure that requests are responded to in a timely fashion and are responded to in a way that's as complete as we legally can respond to the request. There are some instances where due to exceptions in the statute or other legal considerations, you can't provide a complete FOIA response to a FOIA request. But I always try to respond as completely as I can. So.
All righty, we are at the finish line. Do you have any questions for us?
I guess, yeah, my first question would be, what are you all as a county board of commissioners looking for in this position?
Monteith and I have been pretty much given the same answer every time, but I think what we look for is an understanding that, the board writes the policy, you keep that position keeps us out of trouble, basically. Make sure that what we're doing is compliant, and then when the will of the board does come forward with something, making sure that we can execute it appropriate legally, without getting ourselves in hot water, I guess, or limiting county's liability, but what we're trying to do here. That's what I look at corporate counsel for. Talked a little bit about the transition of that office. The number of dollars that we were spending on outside counsel was just you look through our past budget cycles and when we didn't have a corporate counsel, we were spending close to $1 million on outside counsel. It was at least budgeted that much. We didn't quite hit that number, but we were spending an awful lot of money. And the amount of dollars saved internally by keeping the same institutional knowledge, but from case to case, the same sort of relationships with the department heads and the employees in the county. I think there's a real cost savings by having an office of corporate counsel, not just an individual, but an office that can kind of work collaboratively as a team and inform this board the best direction possible, again, while keeping us out of hot water.
Would you like to go, Commissioner? So one thing I had shared as we were asked this earlier too is, providing that legal advice and recommendations to the board in a concise and understandable way, for lay people on the board that really have that sort of, high level vision so you can understand strategically the impacts and really distill it for us so that it's not made overly cumbersome and complex, but helping kind of cut through the legalese and talk to us like people to help us be informed and make effective decisions.
Thank you, Commissioner. Do you have any additional questions, Joe?
Can I just do a quick response? Is that okay, or, okay? I'd like to respond to both commissioners. I think, Commissioner Taylor, what you're saying makes a lot of sense. And I think that it's something that's very doable. One of the things that I haven't talked about in this interview, but that I did do in Canton after arriving about 3 years ago, is kind of a factor analysis of the department. What was it that the lawyers were spending their time doing? How much time was being spent on litigation? How much time was being spent on FOIA response? All those kinds of things. And then kind of after figuring out what the division of responsibilities were, within the department, I looked at attorneys who ended up becoming contract attorneys, for the township, to fulfill those roles at a fixed cost. And so I started kind of looking for subject matter experts. We have a contracted police legal advisor for our police department who helps with, policy making, right? We revised our use of force policy, trains the officers on constitutional policing, assists with IAs, internal investigations. And this is someone who does this for many communities throughout Michigan, but the cost is fixed. He provides the subject matter expertise, and it's incredibly efficient. And the police department loves it. We've done kind of the same thing for some of the other roles. I mentioned, employment and labor matters take up a great deal of time. And while I kind of handle the bulk of that, internally, we also have, a contracted attorney who, we can consult with on a fixed cost basis that provides great expertise to the township on those matters. And we have a couple of other arrangements like that. But again, I think that's probably kind of the first step is, figuring out what people are actually spending their time doing, right? And then kind of, looking for the most cost-effective ways of doing those jobs. But I think you're absolutely right. Without in-house counsel, it's difficult to keep that institutional knowledge. It's difficult to keep those efficiencies within the department because the longer you're there, the more you do any job, right? Not just legal job, the better you become at it and the more efficient you can be with it. So I think that's very doable. And, Commissioner Strebs, to your question, one of my favorite books that my father actually gave me when I was 18 and I graduated from high school is Harry Truman's book, Plain Speaking. And it's a book about, kind of like your question, right? How to distill complex things into, into into language you can understand, simple language. And so that's something I really try and do, in my position. Don't always succeed at it because sometimes things are complicated. But definitely something I try and do, in the role that I have.
Thank you, Joe. Kevin, I'm sorry, Administrator Catlin, can you talk about next steps for us, please?
Absolutely, Chair, Board of Commissioners and Joe. So the board will, they have one more interview to conduct yet this evening, and then they will reconvene on August 7th during their regularly scheduled Committee of the Whole and regular meetings. I anticipate that the board will deliberate during the Committee of the Whole schedule at 4 o'clock, narrow down their candidates to a successful candidate, and then they'll vote on a contingent offer of employment during that regularly scheduled meeting at 7 PM. So we'll be in touch with the successful candidate on next steps after that meeting is over on August 7th. All right.
Thank you so much.
It'll go red when it's on. That's that thing.
Hi, good evening and welcome.
Thank you.
Thank you for taking the time to meet with us tonight. Excuse me, we have 10 questions. We'll each go around and ask you two, and then we'll give you an opportunity to ask us questions at the end. Is that okay?
That's fine. Thank
All
you.
right.
Thank you for having me.
Yeah, thanks for coming. So I'm Tammy Ray, I represent District 1, and my question is, can you please just provide us with a concise 2-minute overview about yourself, specifically highlighting your education and experience as they relate to the position of Corporation Counsel?
Sure. I have 32 years of legal experience. I spent about 9 years here in the Kalamazoo County area doing litigation work, mainly for insurance defense work. So a lot of personal injury, property damage, that sort of thing, but some estate planning and just your general variety for 9 years with a couple different firms here. I spent 2 years before that with the Court of Appeals. I did some pre-hearing, so I worked with a lot of the appellate judges and learned the ropes on what goes on behind the scenes at the Court of Appeals. And after 9 years here in private practice, I went in-house to the Attorney General's office. And I was in their satellite office in Grand Rapids, and I was assigned to the labor division. But most of our work in that division was for the unemployment agency. So I did a lot of, separation work for workers who were separated from their jobs. After that, I went to Treasury in-house, and I did that for about 10 years. I had been in the Grand Rapids office. They moved me to Lansing, and there was a lot of opportunities in Lansing. And I was able to broaden my skill set by joining the Treasury Tax Policy Division. I've really learned a lot in that particular job. There, I have worn a lot of different hats. And I'm not sure if the 2 minutes, I forgot to look at the clock. But we handle our own small claims litigation. We also manage the Assistant Attorney Generals for higher value litigation. So we're managing outside counsel in that respect on tax litigation. We draft legislation, we meet with legislators, we testify in front of the legislature. I draft a lot of taxpayer guidance. So a lot of the revenue administrative bulletins, if you're familiar with any of those from either the state or IRS level. I draft a ton of taxpayer guidance. We do general problem solving. We help administer and implement statutes. I am also the liaison for our 12 Native American tribes that are federally recognized in Michigan. So I have been administering the tax agreements that we have with 10 of those tribes and working steadfast to try and bring the other 2 on board.
Thank you.
Thank you very much. I'm John Taylor, District 5. Imagine the county is facing a lawsuit regarding a land use dispute. How would you approach defending the county, and what steps would you take to mitigate any potential negative impact on the county's operation and public perception?
Well, with lawsuits, you always have to obviously look at the complaint, review what the matter entails, find out what your available defenses are. You know, I would need to legally research that area of law because that's new to me, land use. And that's what I've done. I picked up tax experience. I know 5 or 6 different taxes, within a 6-month period. So I would get up and running on all types of matters that you might encounter. But I would want to review the complaint. I would want to research the law. I would want to ask questions about the department that is, most involved with the particular lawsuit and find out what our potential defenses are, find out what the facts are. And then you'd want to file an answer, of course, and usually that will work into a discovery situation where you're trying to exchange information with the opposing party. And then you want to try to mitigate the risk of your litigation budget exceeding what the value of the case is worth. So obviously you're going to want to find out, well, how much is this damage that you have to, or whatever the compensation is, and you need to weigh that against what your litigation costs are. And so, you have to kind of determine what your plan is for pursuing the litigation. And obviously that determines your costs. And then you weigh that against whatever potential result you're hoping to achieve. That's essentially how I would handle every lawsuit.
Hello, Ms. Jensen, I'm Dale DeLu.
Hi, Dale.
If a county department head approaches you with an urgent legal issue involving a potential contract violation with a major vendor, what immediate steps would you take to address the situation and protect the county's interests?
I would find out who my contacts are, first of all, and ask all the relevant questions about what the matter involves. So what is the violation? Who breached it? How was it breached? And what can we do to maybe retreat or back up the damage and see what we can correct and what we can reconcile. And then basically you would have to do damage control. You would need to, you would probably need to set up, once you get the breach corrected and reconciled, you would need to determine what damages there are. You'd have to sort those out, and you'd have to set up procedures and protocols to avoid future breaches and violations.
I'm always still writing as we move on to the next question, so thank you for your patience. I'm Commissioner Stubbs. I represent District Number 2 here in the county. So suppose you discover a recently implemented county policy may unintentionally discriminate against a specific group of employees. How would you address this issue and advise the board on the necessary legal and procedural steps to rectify the situation?
Well, I would first get a copy of the policy. I would review it and determine how it breaches or violates or discriminates. And so I would research the appropriate law, find out, what the population is and what the grievance is. And then I would probably prepare a memorandum with those relevant facts and law and then recommend a course of action to correct the policy and try to mitigate any damages that might flow from having this unintentional breach. So I think that's troubleshooting, whether there are any potential lawsuits out there, any discrimination claims, any EEOC claims. And so I would want to make the board aware of any potential litigation risks they have and potential changes in policy they need to make and the reasons for that and the legal basis supporting it.
Hello and welcome.
Hi, thank you.
Yep. Montice Morales representing District Number 3. This is a scenario-based question. You are tasked with negotiating a settlement for a high-profile lawsuit against the county. What factors would you consider in your negotiation strategy, and how would you ensure the best possible outcome for the county?
Well, I would determine what the objectives were for the county, first of all. I think you need to figure out what goals you have and what end result you're looking for. What do you want to achieve? And then I think you look at, your weaknesses and determine, how you can mitigate those. And then I think you have to determine what leverage you might have against the opposing negotiator. And then I think you set out a strategy where you leverage those strengths that you have and maybe whatever leverage you have on the opponent. I would definitely want to keep the board in the loop on those negotiations, given that it's high profile, and make sure that all offers are communicated back to the board. And I would definitely want to prepare memorandums advising the board why a particular offer was either inappropriate or insufficient or inadequate, and also counsel them as to what might be the best course of action to obtain what we are looking for as a goal or a result.
Thank you.
Imagine you have to advise on a legal matter involving a potential conflict of interest for a county official. Excuse me. How would you approach this sensitive issue to ensure ethical compliance and maintain trust within the organization?
So it's the council person that has the ethical issue? Just want to clarify. County official has an ethic, okay. First of all, I think I would approach the particular official and make sure that they're aware of the situation and the potential ethics that are involved. And I want to see if there's any education that needs to be done with respect to what the ethical problem or situation is. And if we have a compliance issue, or if we just have an unknowing, unintentional, ethical situation. So I guess I want to get a read on that from the official. And then I want to determine, their willingness to cooperate to correct the ethical situation. And we can work together and collaborate on a plan to correct the situation and make sure. Then I think if we can do that, between those parties, that's great. If not, I think we need to probably make the rest of the board aware of the issue if there's still a compliance issue, or if that person's unwilling to disclose it, for instance. Those sorts of things are all relevant to handling an ethical issue with a particular official. Making sure that you're straightforward with them, making sure that you're building trust and showing integrity yourself so that you can expect that back from them.
Thank you.
Under Michigan's Open Meetings Act, when may the board properly enter a closed session to discuss?
I believe I just read this the other day, but I've read so many things in the interim. I believe it's after a motion to go into closed session, and that's all I can recall. But I did read that recently, and I went through a lot of your minutes, but unfortunately, I don't recall the exact details. And that's why I think it's so valuable just to have your resources on hand at your fingertips. It's not something I use on a daily basis, Robert's rules, of course, but I am on a board. It's a very small nonprofit board called the HHH board. It's the Hospitality House for the Borges and Bronson hospitals. So I primarily serve on that board to do some legal advising as far as some employment issues, some bylaw updating, and some governance type issues. So we don't often have to refer to Robert's rules, just the nature of the informality of the organization doesn't dictate that we refer to them very often. But my goal as a lawyer is always to make sure that I'm well informed enough to, or have the resources to be well informed so that I can advise properly. So I'm not sitting here telling you that I know all the rules to Robert's rules today, but I can get access to those rules quickly and need to know on a need to know basis. And just like I learned tax law, I mean, I'm a prolific writer of guidance in tax now, and who would have thought that 10 years ago, to be honest. So I apologize. Can't give you any more specifics on that.
Appreciate your honesty. Thank you.
Can you describe your experience with labor relations, particularly in dealing with personnel conflicts and collaborating with Labor Council? Please provide specific examples of how you have handled such situations and the outcomes achieved.
I would say I have relatively little experience in labor negotiations, to be perfectly frank and transparent. I have not negotiated with a labor organization. I have read many transcripts of misconduct and other violations for employees and employers disputes, but those don't rise to the level of negotiating contracts for labor particularly. So I've negotiated a lot of other contracts, just not labor. So for instance, I've negotiated contracts with other sovereign governments, tribal sovereign governments, to come to agreements on the gray areas of tax where we can tax and where we can't tax with regard to federal Indian law and federal Indian lands. It's just the nature of what I do in my job, but my job doesn't and hasn't over the last decade or two involved labor negotiations specifically.
Found it. All right, our next one is, how would you ensure compliance with the Freedom of Information Act?
How would
within
I
the
what?
county? Ensure compliance with the Freedom of Information Act within county government.
Well, I always refer to the statute when there's a FOIA question, because there is a statute that pertains. And we do have a FOIA coordinator at Treasury where I work now. So they generally handle most of that. But obviously, the nature of that act is to show and to give transparency to our citizens and our community within the bounds of confidentiality required by our various bodies. So I would refer to the law first and foremost. I would also engage with our FOIA coordinator, because I understand we have one here. I would ensure that the law is being followed and that we have protocols in place so that it's easily followed without having to check on that every single time a FOIA request comes through the door. So I think you have to have a system. I think you have to have that system designed to flow with the dictates of the law, the FOIA law. And I think you have to do periodic monitoring and tracking to make sure that your systems are in place and that you have good internal controls.
Thank you.
All right, you made it to the finish line. Do you have any questions for us?
I made it to the finish line already.
Already.
I just talk fast. I'm sorry.
No, you're good.
I have really no questions. I asked a lot of questions of Kevin previously. I've asked questions of Dina and the talent agency. I've also explored your website to a great extent. So I'm making assumptions here that you're going to meet on August 7th based on your minutes, that you will deliberate so that the other members have a chance to observe the recording. Is that correct? That's right. Okay. And after that, I assume you'll be tendering some sort of offer, whether it's a contract. And I guess I'm curious, do you have a length of time that you normally do that for, or is it just by candidate or by?
My understanding, Kevin, it would be a county employee, correct? Not a contract?
Yes, Vice Chair. So, Board of Commissioners, so typically, because yes, this is a contract position, that we would engage Matt Norfield to negotiate the contract in consultation with myself and the board leadership. Yep.
Sounds good. Thank you. Thank you.
And I don't think I have anything else unless you want to share anything with me.
We don't have anything. Thank you for coming.
Thank you. I
Have a good
appreciate
night.
your time tonight, and I'm glad you could get out before 9 o'clock at night.
Chair, can I make a motion?
Sure.
I make a motion to request for consideration and approval of a financial transfer to the Kalamazoo County Land Bank Authority as written in our agenda.
All right, it's been properly moved and supported. Is there any discussion? All right, seeing none. All those in favor?
Aye.
Any opposed? All right, the motion carries. Commissioner Strauss?
Thank you, Chair. I would like to move the Kalamazoo Community Foundation be appointed as a third-party administrator of opioid settlement funds not to exceed $250,000, and that the administrator's office enter into a contract negotiations with the Kalamazoo Community Foundation for this purpose.
All right, it's been moved by Commissioner Strauss, supported by Commissioner Morales. Any discussion? Administrator Catlin?
Thank you, Chair. I will be quick. Board Commissioners, so along with this motion, doesn't need to be in the motion necessarily because we can use administrative discretion, but if we can have a discussion on what you all would like the maximum dollar amount to be for the micro grants. And then within Civic Clerk in that memo, there was some options to select from as far as scoring the applications that Lindy put together, and then decision makers from the county to work with the KCCF or KZCF on the final grant application and reporting requirements. So not anything that needs to be put in the motion. We can do that administratively, but just some discussion around those topics, please.
Vice Chair?
After reading the memo, I agreed with the quickest option to get the money out there, and that I believe that was the staff of the KCHS. That saved about 4 weeks off. As far as maximum amount of money, I would like to keep the micro grants smaller, not so small they don't do anything, but smaller so that you can get as many of them out there. I don't want to see, like, for instance, $100,000 grant eating up more, like almost half of it, if that makes sense. I'd like to see a lot of $25,000 grants and that sort of stuff. I think because that way, if not every single one of them is 100% successful, one or two of them might be a home run that have a positive impact, and then we can use that information of how this kind of goes to where we need to put larger sums of money. That makes sense.
So I didn't look at the information of Civic Clerk. Has it been decided on like what the funding can be spent towards? I just felt like we had no discussion and then it's just moved.
I believe, Chair, that obviously because Deputy Administrator Smith isn't here, but I believe that the intent is to, if we work with KCZF, what we would do is bring back that kind of, basically the qualifying. Oh, Lindy, never mind. That's great. Hey, Lindy, thank you.
Hi, yes, can you hear me?
No, Lindy, we cannot hear you, unfortunately. I can see that you're talking though. A better way, Lindy, if you wouldn't mind, you can call my cell phone and then I can play into the mic here.
It's moved in here.
Okay, you're on.
All right, and I just want to make sure everyone can still hear me okay?
Yep, looks like it.
Okay, yeah, so, from the discussion that we had, I believe it was one of our June meetings, I was just tasked to work with, to seek options for a third-party administrator for for the mini grants for opioid remediation. In those conversations that I've had with the Community Foundation, we have kept that very broad, so it would be broad regarding just specifically activities that would address immediate needs for opioid remediation efforts. The task force is in the process still, like looking at, the various ways that they would like to focus, maybe the longer term and larger projects. But I think at this point in time, we were keeping it broad, and that it would also have to, per our settlement agreements, be tied to the activities related to Exhibit E. So that's been the primary intention that we have been looking at, but open for discussion for sure.
That's fine. Thank you, Lindy. So when you were, excuse me, having discussions and seeking a third party administrator for the grants, is the Community Foundation the only folks that you talk to? And then like, what are they charging us to administer the grant?
And then Kevin, do you mind repeating just a part of that? I think I heard the first part. Did I talk to anyone else? And then what was the second part?
So, yeah, Chair Ray asked if you had engaged other third-party administrators besides the Community Foundation.
Yeah, so primarily from the discussion, I took that and just met with the Community Foundation. I did reach out to a couple of other foundations, but they had directed me back to them not having the capacity to do it. So I was directed back to the Community Foundation or to United Way. I did not reach out to United Way to discuss the possibility with them. I know that we have recently worked with United Way for gun violence initiatives and also for the recent tornado relief that I know that they're focused on implementing. So primarily at this point in time, I've only talked to the Community Foundation.
Oh, yes, Lindy, what's their rate? Was it 7 to 10%?
The Community Foundation, I think the information's within that memo, but from my memory, I believe it was going to be 7%, and that would be $18,750 out of that $250,000.
All right. Thank you, Lindy. I appreciate it.
Yep, and I.
Clarifying statement. So based on what Lindy and the memo, so what we're approving now is to the overall general concepts with the Community Foundation, and then they're going to bring back to us within probably the next meeting or two. These are the criteria that we're going to score on, and then that staff will, in order for expediency, that staff will do the internal scoring and then award the bids, or the bids have to come back to us to get awarded.
So Lindy, did you hear that question? Okay.
Yeah, I think I did. So what that would look like is, if we wanted to go with the Community Foundation, and if the board directed myself, for example, to work with the foundation to solidify what the application would be, as well as what that reporting tool mechanism would be, then at that point in time, once we have finalized both of those things, we anticipate that would be about a 2-week process. They already have a grant application that they kind of use we do have one that is in draft form as well. So I think they're both very similar. So with that in mind, once the application reporting tool is completed, that'd probably take about 2 weeks. Then that grant would be open. The portal would be open with the Kalamazoo Community Foundation. It would be open for 4 weeks. It would close. And then at that point in time, the Community Foundation would be the decision makers on scoring and then allocating those funds. And that's where those 3 options come into play, whether that is option 1, where it is their staff scoring, option 2, it's already that established committee that they have, or option 3, their board of directors. And so they would be making those decisions, awarding, and also overseeing the reporting back at the end of the report of expending those funds, reporting back to the commissioners with a report on how the money was spent, as well as the metrics associated to that funding.
Quick follow-up then to kind of get to what Chair Ray was kind of alluding to. This is it for us then on the decision-making process. Once we do the dollar amount and the process that they the Community Foundation internally will score it, then it's pretty much up to us. The next thing we're going to get back from them is a report on how the dollars were spent. Okay.
Yes, that is correct.
Yep.
If the board wanted to have like more strict, I shouldn't say strict, but if the board wanted to specifically say, we only want to fund this, prevention and education, or, if they wanted to dive in a little bit more within that Exhibit E, I think we can provide those parameters to the Community Foundation so that they have that lens as they're scoring. But at this point in time, in those discussions I had, it was to keep it broad, and because the decision hasn't been made by the task force of of finalizing their focus point, so to keep it broad for those immediate needs that are occurring in the community that are geared towards that opioid remediation efforts.
I guess I'll just follow up. This isn't a question, but kind of more of a statement. It does make me a little nervous to give up that type of control. So just so that other commissioners are aware, what I view this as, and I'll just be upfront and honest with it, I view it as kind of a political necessity in order to get the vast majority of those opioid task dollars to be spent correctly, and for the community to remain patient while our task force does the work to make sure that they spend it all correctly. That this is kind of one of those options I looked at, is to try to buy us time with the community to say, yes, we're trying to get the perfect solution and we're going to work really, really hard on getting the best solution. But we also realize that this is a lot of money and that there's a lot of problem out there and we need to get money on the streets now. So it's kind of solving one problem and maybe creating another. I'm okay with doing this one time, but I don't think I would be comfortable giving up this much control more than just this one time. But that's my sense. But I'm perfectly okay with the will of this board, whichever direction they want to go.
I agree. It does feel like we're like here, and we've never done that with the United Way. We've always been like standing over their shoulders. I guess for me too, I feel like I need to see or want to see their scoring criteria in the application. We've never seen that. When we first started working with the United Way to distribute out these small grants, we kind of went through it. We kind of, to make sure there was some equity there and all of these things. It aligned with our values and our beliefs. And we're not doing that. I don't know. It just feels really weird to me as well. So if we could see some of that stuff before it goes out, I think I'll be a little more comfortable. But it just, like John, it's a little sketchy and weird for me. Commissioner Morales.
Thank you, Chair. So I'm in agreement with both of you. In my experience with dealing with dollars like this and giving another entity sole control, as opposed to, as you say, not hovering, but, having that direct connect with who's distributing the dollars. In my experience, when you just give a huge amount and the amount I dealt with was over 100,000, that when we lose that autonomy to have some control over it, the dollars went so quick that all the need wasn't addressed within that time span, as opposed to when it was reviewed and, in that case, it had a rubric as well. However, when it became under that entity, then the entity was like, well, you gave us the money, you can't say anything anymore because we've already established that agreement per the MOU or whatever it was. And so I had seen money that lasted a year, let's say 300,000, that between July and, let's say March, that money had exhausted. We had like not so much left, and then we couldn't continue to serve the community. So I agree with having some tighter monitoring on that, seeing what their rubric is, their questionnaires, and how they're going to distribute it. Or as we still work on, I'm on that committee, work to see how we can better allocate those funds where we're not running into a situation where we're blowing through $250,000.
Thank you, Chair. The, thank you. So I think that Deputy Administrator did lift up that the first plan of these couple of weeks was to develop the matrix and the application with our feedback. The portion we may not be involved in the scoring, and perhaps that is part of the contract negotiation. We want a seat at the table to be part of scoring. But I think we do have an opportunity, from what if I took it the right way, to provide, here's the criteria we want these measures rated on. But in this circumstance, this is money we want it out the door. I mean, we don't want it to last, a long time. We have other resources. We're going to be more planful. I think I generally agree with the amount lifted up by Vice Chair Taylor, 25,000. Maybe we could be open to maybe 30. It would give us then, 10 grassroots organizations. I think we also may want to consider, because as it's being lifted up, we want to address immediate needs. So prevention and education programs, those are like longer term. It takes a longer time for those sorts of approaches to have impact. But where harm reduction, treatment, housing, those are like immediate needs. And there's lots of examples in Exhibit E. Deputy Administrator has referred to that tell us like what are in each of those categories, what are appropriate uses according to the lawsuits. So, want to be open without overly constraining our grassroots orgs. We want the money out the door, but we also, as you said, Chair, want to make sure our values and intention with the money is protected. So.
Vice Chair.
What if we did this? I think you're looking for direction, Administrator Catlin. What if we just had, in that I think one of the options, the quicker option with the staff was like 6 to 8 weeks. What if we didn't necessarily had that, as far as we added a couple weeks to it? I mean, for me, scoring that would be absolutely horrible. I don't know that. That's not my strong suit, but Commissioner Strabs, Chair Ray, Commissioner Morales, they have more of they serve on this task force. They have can you keep those 3 commissioners up to speed on this as the process moves, and then we can maybe vote on it on maybe the meeting on the 30th or our next meeting that we have a little bit more information, and we can go from there. Does that make sense to everybody? Because quite frankly, I trust you 3 more on that than on this issue than I do necessarily. I trust Commissioner DeLue if it came to law enforcement stuff. That's the strength of our board right now on this.
So yes, Vice Chair. So I want to address a couple of points. So Commissioner Strebs asked about and the board really asked about kind of customization of the application and having some board thought into that. That is possible, and that's outlined. So we have estimated 2 weeks. They can solicit our feedback, we can incorporate that into the actual application. And as far as, and I'll need Lindy to opine, she's been the one, really meeting with the KZCF. But the options that were presented, the option two is, I would say, the most inclusive option. However, it still doesn't, it doesn't allow for Board of Commissioners, but I believe that we can ask that we have representation from the board in on that committee. Is that correct, Lindy?
Yeah, yes, I think so. And that's what I was going to say. I mean, I'm just bringing forward, the initial feedback received, but I think that they're open to, if we do have a desire for one or three of our board members to maybe be part of that scoring opportunity, I think that's something I can definitely follow up with them and see if that's an option. I think also if we're looking at, we have a scoring application, we have a scoring matrix, and then also what that reporting tool is going to look like. If the board desires for those to come back and to be presented either to the full board, or if the direction is given, hey, these 3 or 4 commissioners are, you need to circulate it with these 4 for input and consensus, I think that they'll be open to that as well. This is just kind of the blanketed proposal, but I think if there's something that y'all would like to see, we can definitely talk back with them. And I think I could probably have an update to you from those conversations at our next meeting on August 7th. And then from there, have a little bit more of an idea of what direction y'all want to go to.
Thank you, Lindy.
I think that works, Lindy. I also too, I don't want you to misunderstand. I don't have to be a part of the scoring committee at all. I just want to see the matrix and the questions being asked in the application. I don't need an extra meeting. Okay. All right. Anything else, Commissioner Strips?
I just, I guess I could have done this offline, but I don't have a link to the civic clerk, the memo that we're been talking through. It's not within my material, so I don't know. We have ongoing stuff with my civic clerk sometimes, it looks like, but just to elevate that. Thank you.
It's probably in there. I think there's 2 different ways people access civic clerk. I always stalk John and he does it different from me, and I don't see stuff and he has it. So maybe we need a little civic clerk training. Okay. I'm always watching yourself. I'll be like, how did you get there? Okay.
Agenda, but then you have to go into a packet agenda.
Yeah.
I just don't even have today's meeting.
Okay. All right. You got what you need, Administrator?
I believe so. Yeah, I think yes, we do.
All right. So we did have a motion on the floor. Do we need to, can we postpone it or do we just vote it? All right.
You can
All right.
put a motion forward to postpone to the next meeting.
I think we're good to vote on it with the understanding that if we go with option 2 and Commissioner Morales or Commissioner Stravis wants to sit on that, I don't see the community foundation saying, no, you guys can't sit on in this meeting. I think that they'll be receptive to that. So I'm good with voting on it.
All right. All those, we're going to call the question. All those in favor?
Aye.
Any opposed? Any abstentions? All right, the motion carries. Commissioner Stravis, you got something you want? No. All right. So now, next item on the agenda is public comment time. This is the time when anyone may address the board on any topic. If you would like to address the board, please come to the podium. Please state your name and tell us where you're from. Please limit your remarks to 3 minutes. Your time is displayed, and once your 3 minutes are up, your time to speak is finished. This is a time to provide input in a professional, respectful manner. Are there any members of the public who wish to make public comment at this time? Mr. Terrell? Seeing none,
Since there's no members time, or is there going to be members time?
there's not going to be members' time.
Okay, can I do public comment then real quick?
Please go to the podium. No, I'm joking. Yes.
I just want to compliment this board on what we did tonight. If John McNeil is listening right now, which probably is not through this, we just accomplished one of the biggest economic development pieces this year in the county, with the creation of over 100 and some jobs at $65,000 a year plus. This is a big deal that we just accomplished tonight, guys, and I think it's intergovernmental cooperation with the state and the county, working together with local municipalities at Brownfield or Land Bank. This is a big deal. And I think in the next few weeks, as this becomes more and more public, it's going to be, you're going to see. Thank you.
Thank you, Vice Chair. Any other commissioners want to have public comment time? All right, seeing none, Dina, do we have anybody online? All right. I think, wait, what did he tell me? Damn. No, man, he told me something.
You can say
This is
without
not it.
objection, adjourn without
Without objection, we are adjourned.